Welcome. I'm Joanne, Director of Mediation, co-founder of Interact Support. Interact is a not-for-profit established in 2015 by mediators and lawyers to help people falling through the gaps in the family law system. We now also provide online family dispute resolution services and have expanded to community and neighbour mediation services. What I'm talking about today is how mediation and the other services within the family law system assist people going through separation and divorce. Common question, we're separated, what do we do now? You've got a whole lot of factors to consider: the emotional challenges, making parenting arrangements, financial considerations, making property settlements, and all sorts of other services to help you sort this out without getting caught up into damaging adversarial processes. That's certainly the goal. One of the things that people often get confused about is the difference between separation and divorce. Separation is when one of you decides that you no longer want to be a couple and generally communicates this to the other person. Something that sometimes people get confused about is it actually takes two people to want to be in a relationship for it to continue. The divorce is a formal legal process that ends the marriage after a minimum of 12 months of separation. Divorce in itself doesn't sort out parenting arrangements or property settlements, but there are certain time limits that you need to consider around divorce and making those sorts of arrangements. One of the things I often talk to people about is the lever and the left. Quite often people are at different stages of the separation process, particularly when they come to mediation. I'm a family dispute resolution practitioner who help people at that point of sorting out what's going to happen with the children, what's going to happen with property, financial arrangements, and so on. Often the person that makes the decision to end the relationship has been going through the process for quite a long time, sometimes years in advance, and they can become quite impatient with their former partner who is taking time to come to grips with things. So it's useful to be mindful of that. And the one that's been left may be really caught up in a whole lot of emotionality and sometimes worse. So I do want to talk about family violence because it is a really prevalent issue and something that very commonly occurs around. Sometimes that's the reason for the relationship to end, but sometimes it occurs at that point of separation. So just to be clear, family violence is any violent, threatening or other behaviour that a person uses to coerce or control a member of their family or causes the family member to be fearful. So this is the definition paraphrased out of the Family Law Act. And you'll notice that it focuses on the effect of the behaviour, not the intention. So it's no good saying, I didn't mean to make them be fearful when I made those threats. If you've made threats that causes someone to be fearful, then it's family violence. If you're abusing a family member physically, sexually, emotionally, or psychologically, that's family violence. Sometimes people struggle to recognise that the behaviour in themselves is actually not okay. You've probably heard about the cycle of grief. I tend to talk about it as the rollercoaster of grief because sometimes you feel like you're strapped on and you can't get off. This basic concept of grief was developed in the context of death and dying, but it's really relevant to the end of a relationship because all of those future dreams, the things that you were going to do, sometimes the children you were going to have or the way you were going to raise them together, all of that is gone when a marriage comes to an end or a relationship comes to an end. There can be a lot of grief. And these are really the strong emotions that come through that denial, which this can't be happening to me, just refusing to accept that. And this is quite common. And someone says, no, it's over. Don't want to be in this marriage anymore. There can be quite a bit of denial around that. If we look at the family violence lens, though, that denial can be in the form of minimising violence for protection, or it may be a result of what's called trauma bonding, a cycle that forms in ongoing family violence where it's not constant abuse all the time. There's periods where there's not, and that creates an attachment or a belief that maybe it's going to be better now, maybe it's not going to happen again. So that denial stage, anger is quite common in this case. You can't do this to me. But as I mentioned before, separation is really a time of very high risk, certainly in relationships where there has been a high level of control. And often people might need to think about doing something that's called safety planning. And if you do feel like you're under threat or at risk of harm, then contacting a family violence service or a family dispute resolution practitioner who's able to help you to think through what to do if things do escalate up into a dangerous level. Another stage in that cycle of grief is bargaining. I'll do anything to change this. One of the things that's very common when people separate is that it's not just, okay, that's it, we're separated. Often promises are made that things will get better. Statistics show us that in the breakup and makeup cycle is very common for where there's no particular family violence, generally 2 or 3 times. Where there is family violence, the typical number of times that people break up and make up and break up is somewhere between 7 and 9. And there's a lot of factors that contribute to that trauma bonding where people are used to that style of relationship, but also there's often structural issues where there's dependence, there's control, there's fear, and many reasons why someone might come back into a relationship that's unhealthy. Depression, a feeling that you can't cope with this. Where there's been family violence, that's generally much worse because of the trauma, exhaustion of trying to cope or be a buffer, and generally there's isolation. One of the features of family violence, particularly coercive controlling behaviour, is to separate the victim from their other support networks. So often people are trying to cope with this without supportive relationships. So if you have a former friend who cut you for their relationship partner and they reach out, make sure that you're open to that because they're really going to need your help. And then acceptance. So in hopefully a relatively appropriate process for coming to terms with the end of a relationship, people start to get to a place where they're feeling like they can learn to live with that. Now, where there's been family violence, coercive control, people don't get off. They keep going through this process and it can be really delayed, and you'll often see ongoing abuse, including systems abuse. For example, many, many years in and out of family court, other courts making use of those or making use of the children over a long period of time. So one of the things that our mission at Interact is to try and intervene earlier on in the process so that people don't get into these cycles, which can be so destructive over such a long period of time. And if anyone does have any questions or comments, please feel free to use the chat to ask me to expand on anything. One of the things that people really need to understand if you're separating is that you're entering into a risk-based system. So the police have a role to interrupt violence and they put in place protection orders. They're called different names in each state, but basically they either arrest people in the case where they consider it's high levels of violence or if there are orders that have been breached. But in a lot of situations, they put in place a court order that puts restrictions on how you can communicate or be in the same place with someone. That's through the magistrates court. Sometimes that court's called a different name in some states, but it's generally the magistrates court. Their role is to use these protection orders to keep people apart or to keep a very close eye on behaviour. So what these types of orders say, they tell you what you can't do. Now, it takes a number of hearings over many months in the magistrates court before any evidence will be heard to determine whether or not to put a final order in place. So sometimes people are quite upset by that if an order is placed against you and you don't feel it's justified, but the system is based on risk. If there was enough risk for an order to be put in place, that's where you're going to need to or what you're going to need to work with. The children's court, sometimes that gets involved if there are risks raised regarding abuse or neglect of children, or if children are committing crimes, so they may be involved. But the Family Court, the Federal Circuit and Family Court of Australia, is the court that gets involved if people are unable to reach agreement through family dispute resolution or negotiation. They also process consent orders, so those are orders that you can apply to the court for, or divorce applications. So those are the main parts of the legal system that you may come in contact with as you're going through separation and divorce. So there are lots of different people and organisations that can support you. Counselling, emotional support to come to terms with the relationship ending is a really good idea, because you don't want to escalate into one of those dangerous people or be perceived as such, and you certainly need the support if you have care of children or if you aren't seeing your children. Both can be quite devastating. If things are worse and you need mental health support, you can get psychological support. Normally, you're able to get a referral to your doctor, and they'll normally be able to provide either free or lower cost a number of sessions with a psychologist for you to work through things. If there has been family violence, there's specialist support that can help with safety planning, access to resources, and other assistance, sometimes emergency crisis support, depending on where you are. Financial support, Centrelink may be able to assist. Child support is a regulated system that can help in many cases. Your bank may be able to put a freeze on repayments or something like that if you're having a temporary cash flow problem. There are financial counsellors, so if debt's an issue, then they may be able to assist in negotiating payments or helping to sort things through. Legal advice, you're definitely going to need some legal advice to understand your rights and obligations, particularly things like spousal support for a dependent spouse. Sometimes people think, okay, I'm separated, I don't have to have anything to do with you. But under the family law system, if your spouse was dependent on you, so let's say you have a very young child and they're not able to work, then there may be some obligations that you have. Generally, with legal advice, you're only going to get very general advice until there's an opportunity to fully understand your particular situation. There might be support. You might need support for housing or emergency accommodation. There's huge pressures on those sorts of supports, but there are some services that might be able to assist. If you're needing help with parenting support, and sometimes parents say, well, I've been parenting these children for how many years? Why would I need that? But things have changed. Parenting after separation is not at all the same as when you're in a couple together. Getting support for parenting through some of those programs. Counselling for your children used to be not recognised that children can have mental health issues. I think most of us are aware of that now. And your children certainly may be feeling stresses and strains with the separation, and getting some support that they're able to talk to openly without fear or worry about upsetting you can be very, very helpful for them. And there might be other services and group programs available to support children after separation, and even help phone lines and other sorts of services that they can call. And of course, family dispute resolution, I'll explain a little bit more about that. But what we do is we help people put together parenting plans and property settlements after separation. There's a number of different resource sites. A really good one is askizzy.org. It's very mobile friendly, and it's very easy to search for services that might be useful in your local area, or if you're a practitioner, to help search for resources for your clients. And familyrelationships.gov.au is the government service that provides links to various resources as well. So what to do first? So if you've decided to separate, there's a whole lot of decisions that might need to be made. So who's going to live where? Is someone moving out? Are you going to be separate under the one roof? That's really common as financial and housing pressures make it just really difficult for people to have somewhere to move out to. Often there's a period of time where you might have some insecure housing. If you're going to be separate under the one roof, it's really important that you establish some rules about how you're going to manage things, how you're going to maintain stability for your children, regardless of the housing situation. So getting into, if you do need help talking, if when you try to sort things out, it leads to blow-ups or walkouts or difficulty in having those conversations, then those are the sorts of things that you can talk through with the assistance of a mediator as well. So with regards to the children's care, how are you going to protect the children? How are you going to tell them about what's happening, what needs to change, and how can routines be maintained? It's really important that you think about not just your relationship with your children, but who are the other important people in their lives? Is it extended family? Is it school or people at sport? So how can you as parents help to support your kids to have as much normality as they can as they go through? Because I've talked about grief already. That happens for kids as well, because whatever the stability was in their life before your separation, unless it was really terrible, generally there's going to be a fair bit of grief involved as well. And how are you going to deal with the day-to-day changes? And of course, financial matters. So how will your immediate expenses be covered with bank accounts? Do you trust each other, or are there provisions going to be needed to be made? Sometimes people do an interim division of funds. Sometimes they put in place a requirement for two people to sign to access funds. There's a number of different ways that you can deal with things like that. Unilaterally deciding to clear out the bank account is really not a good way to deal with it. I don't think it really was very clear in the slides around family violence, but financial coercion and abuse is also family violence. So if you're using money to manipulate or control a family member, then that falls under that category of family violence. And of course, thinking about mortgages and how to prevent your credit rating being affected as you go through the disruption. So one thing I wanted to point out is the best interest of the child. Often parents think, oh, well, I know what's best for my child. But under the Family Law Act, it's now very clear how the court would look at what's the best interest of your child. And this is also an obligation that any professionals that you're working with keep in mind and remind you about as well. So the very first point is the safety of the child and any caregivers. So it's not just whether the child's safe, it really extends to the people that care for them and any views expressed by the child. So there are practices that allow for the children to meet with a professional and talk about how the separation is going for them. It's in family dispute resolution, it's called child inclusive practice. If you do end up in court, then they'll meet with a child consultant. There'll probably be a family report. And this isn't about expecting the children to make adult decisions. It's about any strong views that they have and want to share, as well as anything they want to share about the impact of what's going on for them. The other thing that's considered is the developmental, psychological, emotional and cultural needs of your child. So these are very specific to what they need to grow up strong and healthy. Coupled with that is it looks at how each person who has or proposed to have parental responsibility is able to provide for those needs. So if you've been a very absent parent and suddenly you want 50-50 care, how are you going to manage the everyday and the special needs that your child might have? It does consider the relationship that the child has with their parents and other people who are significant when it's safe to do so. There was a change last year about this, the best interest of the child. It used to look at safety and then the relationship with their parents, but it's a much more balanced view of what's going to be in the best interest of the child now. Not to take away from the importance for children of those family relationships, but also to recognise that their developmental, psychological, emotional, and cultural needs are of equal importance. And then anything else that's relevant for the particular circumstances of the child. So each of your children, if you've got more than one, are going to have different needs based on their own individual circumstances. So the system is really set up to look at all of those factors. And if your child is an Aboriginal or Torres Strait Islander child, then it also really acknowledges their rights to have the support, opportunity, encouragement that they need to connect with culture and family and community. So if one parent is First Nations and the other isn't, then how is the child's connection with culture going to be supported? So a lot of information there, but it's really important as a parent you think about how your actions and behaviours and decisions are going to support these needs for your child. So family dispute resolution, just to be clear, it's a specialist form of mediation facilitated by a registered family dispute resolution practitioner. So we're trained at the postgraduate level and registered with the Australian Attorney General's Department. And participating in family dispute resolution is mandatory for parenting matters unless an exemption applies, and it's recommended for property and financial matters. So there is a structure and certain requirements that we have as family dispute resolution practitioners around the process, and it's really important that you do actually work with a registered family dispute resolution practitioner, not just with a mediator who hasn't got the required training to understand family violence and understand how to support you through this process, how to support you both through this process. So initially, there's mandatory information that we need to provide. Usually that's going to be in the form of an agreement to mediate and other resources that they provide you. Please have a look at them. Don't just sign it without reading through, and ask questions if you do have any questions. There is a requirement for a pre-mediation or intake process to make sure that FDR is suitable and also to help you to prepare. If it's not appropriate or if one of you refuses to participate, then the practitioner will issue what's called a Section 60I certificate, and this allows you to apply to the family court for family court orders. Sometimes instead of going straight to court, you might be able to try and negotiate through lawyers, but so that certificate is only at the moment relevant for parenting matters. For property matters, it's still encouraged, and you can provide evidence that you've tried to resolve things through mediation, but there isn't a specific certificate that can be issued. And then the mediation, the family dispute resolution. These days, it's often facilitated remotely. There's a process called shuttle. If there are risk concerns or you're worried about speaking directly, that in that process you don't speak directly. The mediator brings the information back and forward between you. You can also have support people if needed, and they can be emotional support, or it may be that you have your legal advisors there with you. And the outcome that you're trying to achieve in family dispute resolution is stable parenting agreements, property settlement agreements, and ongoing parenting arrangements or adjustments as your children's needs change. So you can come back to family dispute resolution at any time to try to negotiate changes to agreement or even orders. Now, where do you find a family dispute resolution practitioner? There are a number of government-funded services around the country. There are private practitioners that you can work with. There's non-funded, not-for-profit, such as Interact Support, where I do my mediation services. Some community legal services also have a mediation or family dispute resolution branch. Everyone who is a registered family dispute resolution practitioner is on the Australian Government register for family dispute resolution practitioners. So if you have any doubts at all, look the person up on the register to make sure that they are there. Some of the professional bodies, such as Mediation Institute, also have directories of mediators and practitioners. So there's a whole lot of options. And it really depends on your needs. So the government funded services you generally will be the cheapest option because they have funding that supports the payment for their practitioners. However, they can have some restrictions such as waiting lists. Some of them have restrictions on the support people that they'll allow in the services and so on. Legal aid often has a family dispute resolution service as well, so they'd fall under that government funded services. Private practitioners generally are much more flexible in the way that they can work with you, but of course there'll be usually higher fees, and then some of the others might be somewhere in between. So it's really a matter of finding out what fits for you. At times there are challenges with different practitioners, so that's something that you need to work through. If you do have any questions as we're going, feel free to ask. But ultimately, the sorts of things that can be negotiated in mediation are the things that fall under what would be a parenting plan. So a parenting plan is a written, signed and dated agreement about children's arrangements. That's generally between the parents or those with parental responsibility. And it's very important that it is reached without coercion. So threatening or blackmailing or promising financial either consequences or rewards is really not appropriate. These need to be entered into freely. Parenting plans cover where the children will live, who they'll live with, who they spend time with. We don't use, and we haven't for quite a number of years, terms like custody or contact visits because the children aren't in jail. And so where they live, who they'll spend time with, changeovers, so how they get from one person to the other, all of that can be discussed. Day-to-day care, communication between the children. Sometimes there's a need to discuss communication between the parents, and there might be clauses in an agreement about not denigrating. It's really, really, really bad for your children if you're saying horrible things about their other parent in their earshot, and it's actually really bad for your relationship if you are as well. So getting back onto a respectful footing is definitely something to try and work towards, but definitely protecting your children from that. Sometimes parents think it's going to be easier if they get the children to be messengers. It's really bad for your children. Don't do that. And your practitioners will help you think about ways that you can communicate without dragging the children into that sort of thing. Parental responsibility, basically parents are responsible for their children and for joint decision making unless that's not possible. So if because of family violence or because of conflict, it's just you're not able to make decisions, sometimes there has to be an agreement about who is going to make decisions or make certain decisions. It's less common for parents to give that up voluntarily, and it may be something that you end up in a court order if you're finding yourselves just unable to make decisions. Hopefully, you're not going to find yourself in that sort of situation. Other decisions relate to education, health, and any special needs that your children might have. Sometimes there's controversy around things like vaccinations or other approaches. And again, if can be something that you reach agreement about. If not, then again, you might need someone else to make decisions for you. Travel, including overseas travel. So if there are concerns about whether a parent would take the child overseas and not return them, those are things that might need to be discussed. There are processes such as airport, if that isn't trusted. Often in mediation, there's negotiations around passports and who's going to keep them and what information needs to be shared about travel. Ideally, if your family is one that does travel or the children have family members who are overseas, it's great if they are able to be part of their lives. So negotiating a way that can happen safely, sometimes that can be done in mediation. Information sharing, that might relate to schools and other things. Some schools are really quite behind the times and they require a primary parent and they won't share with other people without special permission. So sometimes that takes a bit of negotiating and working through. a lot are more aware of it. Often there's multiple people that information should be going to. And of course, safety, if there's any particular provisions. So sometimes we're working with people to start negotiating contact after there has been a family violence incident or risks, and that might involve supervised contact, or it might involve supervised changeovers between parents if you're not able to be civil with each other for the sake of your children at the moment. And all of that can be negotiated. And of course, extended family and culture. So things like special days or special cultural ceremonies, they can all be part of a parenting plan so that everyone knows in advance what's going to happen. Financial arrangements can be in a parenting plan. It's usually not the basic child support. It's usually things like paying for extracurricular activities and so on. For children, often working out how those sorts of activities are going to be decided. A big area of frustration for families is often when activities are arranged for times where the other parent would normally spend time with their children, working through all of those sorts of issues. A good parenting plan will normally have a process or triggers for reviewing the plan, and it would normally have a process for resolving disputes. So the fact that you have a dispute about what it means in your parenting plan or that you need to change something doesn't mean you need to go to court. You can come back to mediation and work your way through why it's not working for either or both of you and what could be done instead. So lots and lots of information. Your family dispute resolution practitioner should be able to give you some tools or templates or resources to help you think through the options or what might be important for you. And not everything needs to be in the plan. It really needs to be the things that can be a little bit controversial for your particular family or that relate to special needs that your particular children have. So just a note on the legal status, I'm not providing you legal advice, I'm just providing you with legal information. Parenting plans aren't automatically enforceable. You can't run down to the police station and say, this is what my plan says, they haven't done it, and expect the police to enforce it, but they can't actually do that even with a court order. Generally, you should go and get an enforcement order before the police will actually take certain actions. That can depend. If there's welfare concerns, then of course go to the police and say you've got concerns about a child and they may be able to assist, but more from the point of doing a welfare check. But it does have some status. So the most recent parenting plan must be considered by the family court if you end up in court. It doesn't say it has to be enforced by them, it just needs to be considered. And it may modify the terms of a family violence order from the magistrate's court, only if it specifies that a parenting agreement can modify the terms of the order. Generally, they do allow for mediation to occur. Not always. It just depends on the magistrate and the order. If you try to go to family dispute resolution and there is a family violence order, they'll want a copy of the current order before they can make a decision about whether or not they're able to assist you. And it may also make the terms of a parenting order unenforceable. So if you have a parenting order but you need to update it, you don't have to go back to court. You can negotiate a parenting plan that modifies the terms of that particular order so that the new parenting plan has what's going to happen. Okay, and you can also have a parenting plan turned into consent orders, so into court orders, but administratively by an application, so it doesn't require a full court hearing or hearings. It's a process that's considered by a registrar in a back office somewhere. You see, it does have some significance. So if you have any doubts at all about what's being proposed and what you're agreeing to, get some legal advice before signing a parenting plan. It may also have some significance in terms of child support and as well. So quite a number of different factors. With property settlements, so there's quite a structured process to reach a settlement around your property. So you need to first determine the property pool. So that's everything you have, everything you owe, and your income from all of your sources. So all of that needs to be disclosed. You need to discuss the contributions and future needs. Contributions are any financial contributions that you made at the start of the relationship and how long ago that was. The longer ago, the less that may have weight, I suppose. So 20 years compared to 2 years, there's a difference. The contributions during the relationship, so the financial and the non-financial contributions. So it's not just the money you brought in, it's the things that you did, having and supporting children, renovations, making improvements on the property, direct and indirect. So whether it's from wages and salaries, inheritances, or gifts from family members or support in other ways, those are all factors that need to be considered. The future needs, so that includes any dependent, the children, who they're living with, your relative ages, health and other factors. The impact of family violence is now clearly identified as a factor to be considered. So in terms of contributions and how it may have impacted on the contributions that a family member might have been able to make, and also future needs. So it's a lot of factors there. There isn't a formula. You can't plug it in one end and out it comes on the other saying, yes, it's going to be this percentage. But they're all factors that go into the making a decision. So then the process is to negotiate a fair and equitable property settlement. And some of the other factors, if assets have been sold, so sometimes people start preparing for their property settlement and try to hide assets. There is a duty of disclosure, and there are strategies that are available to try and identify disposed of resources, generally not in family dispute resolution. Generally, you're going to need to get more expensive processes involved if you're unfortunate enough to be caught up in that sort of situation. But ultimately, once everything's out on the table, and if you are able to negotiate a fair and equitable property settlement, there's usually some tasks that need to be completed. So if you identify any assets to be sold, then negotiating how that's going to happen, how reserves will be reached, how costs will be managed, all of those sorts of things need to be worked out. Identify any assets or debts to be transferred and any repercussions, so capital gains tax and things like that. You might need to get some financial advice and list any assets that are going to be retained. Generally, we recommend that you get consent orders with property matters. And again, once you've got everything sorted, you need to provide all of that information to the court, and they can make an order that will allow things such as superannuation transfers to happen without any additional costs, properties to be sold, and all transfers without costs as well. All of that. So there's a fair bit to happen to make a property settlement happen. There's different ways that you can negotiate that. Each have got pros and cons. So some people directly negotiate them. So that's fine if you're not being coerced and you both got a good understanding of your financial situation and there's no risks of non-disclosure. That's fine. But sometimes what people think might be fair is actually not fair. For example, 50-50 might sound like it's fair because you're splitting it down the middle, but in many situations that isn't equitable. Someone might have a much higher earning capacity because the other parent has stayed home raising the children and that's affected their career. So generally there'd be an adjustment for that in the future needs. They may have, again, that ongoing care of the children that's going to impact their earning capacity. So all of those do affect what would be considered a fair settlement. Family dispute resolution, it's usually reasonably priced and an efficient process. In property, expect that it's going to take a few sessions for full disclosure and that you'd go and get some more legal advice once all of the information is out on the table. There are some good software tools available now that practitioners are using to make the process more efficient, clearer in the process as you go. With legal advice, if you get legal advice at the very start of everything, before the asset pool is determined and the considerations are disclosed, it's not going to be accurate. You're going to get at best some sort of an average based on your gender and children and things like that. You're really going to need to get some additional advice once all of that information's out. And what you should be asking the lawyer is, what's the best and worst case scenario if this was to go to court? That'll give you a bit of a negotiating range, I suppose, and also costs. What would it cost you to go to court? So if there's an offer on the table and you think about, well, it's going to cost me X amount and this is the likely range, you've got to balance up those against the ability to get a settlement sorted. Again, the other option is to go straight to lawyers and use them to try and negotiate. It is a slower process and more expensive because of that inefficiency of letters from one lawyer to the other. But it may be the process you need if there is non-disclosure, very high levels of complexity or coercive behaviour. But it may escalate conflict if it's not well managed. So be mindful of that, of trying to work with your lawyer, keep things to a reasonable level if possible. And then consent orders if you are able to reach agreement. If you can't, or if one person refuses to disclose or engage in negotiation, you may have to go to the court to try to get court orders. Most cases don't go all the way to a final judgment. There'll be constant and ongoing pressure to comply with the law and make full disclosure, and you'll generally be ordered to conciliation, which is a court-ordered type of like mediation, where a registrar will try and help you to reach a settlement agreement, or sometimes even ordered out to mediation or family dispute resolution outside the court, depending on your circumstances. So there's still going to be ongoing pressure to try and help you to reach an agreement, because agreements are always going to be better than orders if you can reach an agreement that you both accept to and live with. Unfortunately, sometimes in the system there is, people feel like they're being pressured and might reach agreement about things that they really didn't want to. Trying to keep the pressure and the control in your own hands is really a good idea. So with divorce in Australia, we've got a no-fault divorce. So if you're separated for more than 12 months, then you can apply for a court divorce. The court doesn't need any proof of wrongdoing, any reason for the breakdown, doesn't need any evidence of who's at fault. Even things like family violence don't directly affect the divorce. They may affect the parenting or property issues. So as I've already shown you, it's definitely a consideration in parenting, whether or not your children are going to be safe with you, and with property, how any family violence has impacted the contributions and future needs. But if you do have children under 18, then in the divorce application there is a requirement for proof that there are arrangements in place, not necessarily a parenting plan or orders, but enough information to show that you have, as parents, considered your children's needs and made some reasonable arrangements. So that's divorce. Oops. So there are some time limits. Generally, your property settlement should be done within 12 months after the divorce, and if you weren't married, 24 months after separation. So that's calculated on 12 months to get divorced and another 12 months. Not that you need to get divorced after 12 months. Some people wait for quite a long while after they separate. Anyway, the reason what this means is that the court actually, you are supposed to have to apply to the court for the right to start a property settlement case if the other party won't agree to negotiate with you, if you've waited for longer than that 12 or 24 months without any evidence of that negotiation. So it's usually granted, but it does add cost, and there is the risk that the court might decide it wouldn't be fair and equitable. So I had one case that I'm aware of as an example. The father decided that in lieu of child support, the mother could continue to live in the family home until the youngest was 18, which is about 10 years. The title was transferred to the mother and she refinanced and paid the mortgage and made all the payments. He didn't make any financial contributions to the property or the children in that 10 years. And after the child had completed school, the father asked the mother to sell the house and divide up the proceeds, and she said, yeah, nah, refused. So he applied to the court for an order. The court considered it wouldn't be just and equitable and didn't. He appealed that decision and again lost the appeal. And yeah, he bankrupted himself trying to get that agreement that he believed was made, but there wasn't any records. They didn't keep any papers. There was no evidence that was what was agreed. It's really important if you are wanting to do something unusual after a separation or divorce, such as that you do have it well documented. Generally, a court wouldn't make an order that's going to take 10 years to come into effect, but there are things like binding financial agreements. So there's a whole pile of other questions, but I've spoken too long. So if you do have questions that aren't answered, you can always contact a family dispute resolution practitioner, contact a community legal service or other advice provider. So mediators generally don't provide legal advice, but they can provide legal information, and legal services are, of course, able to provide legal advice. So just a final reminder, at Interact, our mission is to prevent disputes from escalating into violence. And so we work with people to try and help you to sort things out as early as you can. And you can contact us at interact.support. There is an inquiry form. You can contact us to get some further information about any of these sorts of factors.